I'm going to give you the lawyer's perspective on some of the issues we've been talking about today, conveying a message of compliance with the thought of keeping companies out of trouble. And I spend about a half of my time on compliance and about a half on enforcement defense, the MARPOL cases, and I can assure you compliance is a much more economical business decision. So with that, what's happening in the US? Sometimes it's rather puzzling. Sometimes it's puzzling for us to figure out, let alone the international community. What we're going to talk about very quickly is EPA's Vessel General Permit, Ballast Water, MARPOL Annex 6, and the EECAs, a tidbit on marine casualty reporting, and then just a very quick overview of the legislative process in the US and how it affects the marine industry. So EPA's Vessel General Permit, it came into being through litigation after 30 years of vessels operating, discharging incidental to operations. 30 years later, litigation, and we have the Vessel General Permit. It's into its 6th year now, 27 discharges, lots and lots of record keeping. There are a couple changes in the new VGP. Ballast water, there are numeric limits. There are requirements for environmentally acceptable lubricants in all oil-to-sea interfaces. And there's monitoring requirements that come into play for ballast, bilge, gray, and then exhaust gas scrubbers. There are administrative improvements, which is a good thing. It's okay to keep records electronically now, and there's one annual report instead of a couple reports. Enforcement is on the rise. It's something to be aware of. They're focusing the Coast Guard and EPA on the notice of intent, routine inspections, and documentation of the VGP requirements. Importantly, the VGP applies once you hit the 3-mile zone. So outside 3 miles, it doesn't apply. But once you cross that 3-mile territorial sea, or the territorial sea for this purpose, that's when the VGP requirements kick in. So ballast water. I mentioned the VGP has ballast water requirements, as does the Coast Guard. The Coast Guard's mandatory ballast water program went into effect a couple years ago. There are civil and criminal penalties for noncompliance. There are 5 options to comply. Install a Coast Guard type-approved system. There aren't any. Use water from a public water system. I've not met any ship owner that says that's feasible at all. Do not discharge ballast water. Not practical for most ships. There are some ships that can do that, not many. Discharge to a shore-based treatment facility, there aren't any. Complete ballast exchange at 200 miles until you're required to have a system, or use an alternative management system, a system approved by IMO, accepted by the Coast Guard, but the risk there is if you install an AMS and it's not type approved, you've got a system on board for 5 years that then has to come out. The Coast Guard is granting extensions to the compliance date, which is a good thing. So comparing Coast Guard and EPA, the Coast Guard regulates ballast under something called NISA, which is the National Invasive Species Act. EPA regulates ballast water under the Clean Water Act. So the approvals, Coast Guard, you need a type approval. EPA, you do not. What BAT means is best available technology. So testing, Coast Guard standards, ETV, as some of you may have heard, none for EPA. The phase-in date is the same for both. The Coast Guard has granted extensions to compliance. They've granted several hundred so far because they recognize there is no type-approved system. EPA said, nope, we are not granting extensions. So what happens? That'll be the next slide. So you have two regulatory agencies regulating the same thing under different legal authorities. There's a lot of guidance out there. The Coast Guard came out with a job aid this summer that basically tells the marine inspectors what to look for. It's incredibly helpful for ship owners to look at this, because when they're doing, the Coast Guard's coming on board for an inspection, you can see boom, 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 what the inspectors are looking for. So it's a very helpful tool. If deficiencies are found by the Coast Guard, which does the inspections, they're going to encourage you to immediately correct it. They're going to enter the data into their missile system, which I don't even remember what that stands for, but it's their inspection database. EPA then can look at the database and will decide whether it's going to enforce or not. And then EPA would be the agency to issue the penalties. So we call this the Ballast Water Conundrum. So what is a company to do? There are no type approvals and no practical alternatives to meet the Coast Guard requirements. As mentioned, the Coast Guard issued an extension letter. The first round of extensions were good until Jan 1 of 2016. The recent extensions are pushed out to January 1 of 2017, which leads me to conclude that the type approvals aren't that close. EPA took a different approach. They said, if you have a Coast Guard extension, we are going to make it a very low enforcement priority if you don't have a system on board. Well, okay. A low enforcement priority means if you're complying with the VGP, if you have a Coast Guard extension, if you're doing everything else right, we may exercise our discretion to not enforce. Now, what's important is that enforcement or low enforcement does not equal compliance. So in essence, even though you have a Coast Guard extension and EPA says low enforcement, any ballast water discharge would still be a non-compliance, which would have to be reported in each annual report. And that, I think, puts companies in a very, very bad position. We had a big debate in the US with a bunch of trade associations trying to find a solution to this, and it was a very difficult effort. And all of the varying ship types really didn't come to agreement on what the best approach would be. So we're in this conundrum now. Could our Congress actually solve this problem? They could, if they could ever do anything. Unfortunately, our Congress has been the least active Congress this year than almost in history. There are 2 pieces of legislation pending that would fix this. However, politics come into play. Congress is in recess now for another month. This is an election year, so anything that has to get done must get done by year's end. And you have the California factor, where I don't think the California legislators would ever buy in to uniformity, unfortunately. So I don't think there's going to be a fix here. Once the year ends, we have a new Congress, and the whole process starts over again. The Coast Guard bill is something that happens about every 2 years. It may or may not happen this year. There are a couple interesting provisions in it. One relates to the protection of seafarers and a fund for abandonment, mostly at these MARPOL cases. But if anyone wants to talk about that, we can talk about that later. Going on to the EECA. This went into effect a couple years ago. There needs to be written procedures, everybody knows that, lots of record keeping, 1% sulfur, goes down in 2015 to 0.1. So how does the US deal? There is a fair amount of guidance out there on fuel oil non-availability. There are Coast Guard policy letters, there are more job aids, there are frequently asked questions. So many questions that are put forth are published so everyone can see them. Fuel oil non-availability reports are required under MARPOL, a report to flag state and to EPA. EPA has a form. A lot of companies fill out that form. EPA looks at the forms, and if there is a company that files a lot of forms, you might get a subpoena, because EPA wants to try to figure out what the problem is. Is it the company? Is it the availability? Is it the route? A number of the trade associations are calling for strict enforcement, especially when the point 1 goes in, to keep the playing field level. Notices of protest, one big problem we're seeing all the time. You get a bunker delivery note, it says under 1. You do an independent quality test, it says over 1. So what do? Many companies are filing notice of protest to the bunker provider. EPA has also asked that those notices of protest be filed with them. It's helpful for enforcement purposes, and it may help mitigate any potential penalties by being transparent. And what they're really doing now is trying to figure out, is it the bunker provider? Is it the third party doing the sampling? Is it where the bunker sample's taken? They're trying to get a handle on why this is happening. Looking at detentions, I did a quick look and found a number of MARPOL Annex 6 detentions by the Coast Guard. These were largely because the ship was found with non-compliant fuel, did not file a fuel oil non-availability report, and did not notify flag state. So it's those ships that are the ones that are getting detained. In one case, the ship actually had compliant fuel on board, but didn't use it. So these MARPOL Annex 6 detentions are happening. All of this is spelled out in that job aid that I mentioned, the standards for detention. The main focus in the US is environmental compliance. Safety is, of course, very, very important, but environmental compliance is what gets all the publicity. Annex 1, oil record books, the MARPOL cases are continuing and continuing and continuing. They're not stopping. We have several in our office that are ongoing, and as long as problems are found, these cases are going to continue. The Coast Guard has actually started sounding tanks and comparing them with the oil record book. That led to a detention in one case I had just a few weeks ago. Annex 5, there have been a lot of garbage-related detentions. Discharges in the wider Caribbean area, for example, where they're prohibited. Fuel sampling, this is going to be a Coast Guard priority. I don't know what they're sampling, whether they're sampling the tank or the sample. They have not said, but I have not heard either way that they're actually sampling as yet. Enforcement goes to EPA again on this one. Ballast water we talked about. They are reportedly testing salinity to determine if indeed ballast water was exchanged. In my last minute, I'm going to very quickly touch on marine casualty reporting because this has become a big issue in the US. Marine casualties have to be reported if they occur inside 12 miles or if a ship's coming inside 12. A marine casualty is a grounding, an elision, a loss of propulsion or maneuverability. I have that in red for a reason. Unseaworthiness, injury requiring professional medical treatment, that's also a controversial one, or significant harm to the environment. These are hot buttons of enforcement, mostly smaller enforcement actions, but hot buttons. There's a fair amount of confusion as to whether something's reportable or not, and whether it's a casualty or not. The Coast Guard came out with draft guidance to try to assist this effort. They're considering comments right now. What they are recommending and what makes sense is if you think you have a casualty but you're not 100% sure, it's always prudent to report. And the Coast Guard can evaluate and say yay or nay. If they say yes or no. If they say no, I suggest you document it. If they say yes, it means they would consider it to be a casualty. So they got to be immediately reported by phone. A 2692 casualty form has to follow in 5 days. They take this very seriously. All parts. I deal a lot with cruise ships and others. They are getting penalized all the time for either delayed reports or delayed phone reports. If a marine casualty is a bad marine casualty, like a very large oil spill, drug testing is required. And there are timings set specifically for the drug testing. There was a recent case, $75,000 fine, failure to report a hazardous condition. How the Coast Guard looks at it is if there's a delay, we cannot start a response effort if one is needed. And any delay can actually create a much greater risk of a serious casualty at some point. So my message, stay tuned, keep on top of developments, watch what's in the pipeline, learn from others' mistakes, and have a plan in place to deal with these, a lot of these new issues that are coming up. Thank you.